Good morning. No traffic for you this morning. You get the blurry front screen. Sorry about that. I had recorded everything that I wanted to say, and then I realized that I hadn't recorded something that I wanted to say. And instead of trying to go ahead and do a second, much shorter video, I figured I'd smash them both together into one video. First thing is I want to congratulate James Freeman, James Allen Springer, on apparently his charges were dismissed in his Leon Valley cases. So a felony and a misdemeanor were both dismissed. And the Leon Valley lawsuit where, Texas Wolfman, Jack Miller, James Springer, there's like 9 or so, I believe, plaintiffs. Their lawsuit can go forward against Salvaggio and Leon Valley. So congratulations to James Allen Springer for that. For those of you who think that somehow I should not be happy about that, I want to remind you that the point of our legal system is to make people whole for harms done to them, for legally cognizable harms done to them. And being arrested when there is no probable cause for an arrest is a harm. We don't want our police rolling around and just arresting people willy-nilly. That's a ridiculous communist China sort of system to have, and we don't have that. So we want to disincentivize officers from being able to do that. And so in the law, there is a remedy for that. 1983 would be the remedy against a city and a city police force. 42 USC 1983. 18 USC would be 241 and 242 if they were going to face criminal charges, but it's 1983. Anyway, my point being is that it doesn't matter how much I like or dislike James Freeman. I like having a system of laws in place where it protects people, including myself, from facing unlawful arrests. Just like I appreciate a system that protects me and everyone else from being shot at, let alone shot, even if it is just a chip of concrete that hits a leg, even if there is no wound. There is a system of laws in place, at least in the state of California, where it allows you to seek damages, to be compensated for being harassed, humiliated, scared. You shouldn't have to deal with that. You should not have to deal with having a gun pointed at you or discharged. You shouldn't have to deal with being hit by whatever it was, be it a rock chip, be it a bullet, whatever it was, it doesn't matter. You should not be hit by it. No one should, including Furry Potato. I don't care if you don't like Furry Potato. The way the law is there's no exceptions but you're an asshole. It's legal to be an asshole, or else I wouldn't be here. And in fact, I'm encouraged as an attorney to be an asshole. That said, if we started making exceptions, you got to remember that the reaction that Furry received was because they didn't like her actions. They didn't like it. The cop didn't, or the security guard didn't like it. So he took actions. He took actions he was not allowed by law to take. It didn't rise to the level of crime, at least according to the district attorney, but you're still not allowed to do those things you're not allowed to do harm to other people, basically, without them having a cause of action against you to be compensated for it. And that protects Furry from people who don't like what she says. That protects me from people who don't like what I say. And that protects you from people who don't like what you say. Because if you go into Furry's chat and you start spewing all the hatred that you were spewing in my chat, no one there is going to like you. And if they saw you in person, if that crowd of people was there and they saw you saying that in person, they might want to visit harm upon you. And I wouldn't support them visiting harm upon you any more than I would support the security guard visiting harm upon Furry or someone visiting harm upon me. That's just the system that we live in. That's why our system isn't perfect, but this is the best we got. And as far as what pronoun I call Furry, if you want to tell me what pronoun to call her, you can kick rocks. I don't care. No one controls my speech. If if you think that I don't know that she has a Y chromosome, if you think I don't know that she is not a real woman, that she will never have a child, etc. I mean, I'm not dumb. I don't know why you think that that's some novel information that needs to be spread around. I think everybody's pretty much aware of what's going on there. Now, I choose of my own free will to call Furry Potato a her because I don't have any animus against her. I mean, I don't agree with what she does. I don't necessarily like what she does, but she has a right to do what she does. If she didn't have a right to do what she does, then she would be getting a lot more arrests. I mean, when she has crossed the line, she's been arrested, she's been charged, she's been convicted on a few things. But when she's not crossing the line, I mean, you could be an asshole, like I said. So I don't support what she's saying, but I support her right to say it, just like I support the rights of all the other First Amendment auditors to say what they have to say, as long as they're not actually breaking any laws, even if they're being jerks, because everybody has a different definition of what being a jerk is. And I'm not inviting Furry Potato over for a meal, but I'm going to show her the grace of calling her a her, because I don't need to be a dick to her. I'm sure enough people are dicks to her every day. Finally, there's blind justice. There's not a lot to report on this. Everybody keeps saying that he has a right to appeal. He doesn't. He has a right to a trial de novo. It's a new trial. An appeal uses the record produced in the trial court below it, and they look at things as a matter of law. They don't really go into the facts. They don't go into the evidence. What he is entitled to is a trial de novo. The way that North Carolina sets it up is they do all their misdemeanors as a bench trial, just in front of a judge. Misdemeanors are a bench trial. And then if the defendant doesn't like the results of that bench trial, then that person can request a trial de novo with an actual jury, the whole smorgasbord. Most people don't do it, and so that saves North Carolina a bunch of money because it costs money to have jury trials. They're longer. They tie up the courtrooms longer. You have to pay the jurors. I mean, there's just a lot more. There's a lot more to it. Like, that would probably be. It'd probably still be a one-day trial, but you'd have a day of voir dire, and you'd have, I don't know, you might have a day of deliberations at the end of it. You might be able to get jury instructions in on that first day. I don't know. You probably would. I mean, you only have one charge, so you'd probably be able to do the trial and jury instructions that first day. Anyway, it's a lot more involved, more complicated process, and so North Carolina tries to save the expense of that by running people through a bench trial first for misdemeanors before they run them through an optional trial de novo with a jury. So at this point, I want to point out that the judge agreed with me that the stop was lawful, that there was reasonable suspicion. So yay me. I also want to point out that everything I saw a video or a portion of a long video. I was directed to the 4-hour and 5-minute mark of this video, where Blind Justice started talking about all the mishaps in the trial. The cop said that he rolled 40 to 50 yards, and the parking lot isn't even that long, and the informant has a grudge against BJ for some reason, and there's no dash cam video or body cam video of people coming to the stop, and there's, how did this other officer get there? I never saw this officer. I mean, just all sorts of, another fun one is that Blind Justice claimed that the video was edited, that they showed Blind Justice's video and it was edited. I believe they probably stopped it at a certain point, because again, there are only two relevant factors. One is, was the stop justified? Was it a valid stop? Was there reasonable suspicion to support the stop? That's one. Two is, did Blind Justice meet all of the elements of the resisting the officer? And both of those are pretty apparent. Well, excuse me. The resisting the officer is apparent from the video. as far as the stop is concerned, you had a witness testify that things were weird, that they were in the church parking lot. I've been over it before. I think there was reasonable suspicion for the stop. The judge thought there was reasonable suspicion for the stop. I mean, maybe blind justice wants to go through with the trial de novo. I doubt it. If he does go through with it, then everything from this original trial is gone. It's all wiped away. It's a clean slate. There's no presumption of guilt. He's not sentenced to any probation or anything like that. Currently he's sentenced to 1 year of probation. He's sentenced to, I believe, 10 days of community service, and he has to write apology letters to all the officers. No big deal. Once he does the 10 days of community service, I believe he gets back his $50,000 bond. And I have a feeling that rather than part with roughly $10,000 of that for a lawyer to do the trial de novo, I'm sure he'll probably just hang on to that money, because wouldn't you? Especially considering that, it's just probation. Anyway, so that's my take on it. Sorry about the sun being behind me. That's just where the sun chooses to be. Sorry about the steering wheel being in front of me. Hello. That's just where the steering wheel chooses to be. I hope you found that informative. Thanks for watching. Have a great morning.